All right, if we could get everybody to have a seat, we'll get started with our second speaker. Wow, that was quick. Today our second speaker is Theresa Rhyne. Teresa owns a business called Theresa Rhyne Law Group. She's been practicing, our focus is on real estate and charitable planning for business owners, individuals, and families. She's been doing that for over 20 years and in businesses and tax law. She's also written a New York bestseller, The Dog Lived and So Will I. And I've heard her speak before. She is filled with great information that I personally didn't even know existed. So welcome back. Thank you very much.
You've got me mic'd, so.
Oh, you have it? You think that's going to work?
We're thinking this works? This mic, yes? Yes, okay. Great. Good morning. Ordinarily, my topic, which is on estate planning and particularly estate planning dealing with real estate assets, normally death and taxes would come, well, in life and in a conference like this at the end. So I really appreciate the Norris Group accommodating my schedule today. I have to be, he mentioned I'm also an author. I have to be in Pasadena for a book signing at 1, and then I'm speaking on a panel for the California Library Association annual conference. So I'm schizophrenic today. I'm a lawyer in the morning and I'm an author in the afternoon, and you're a little schizophrenic today too because we had to put death and taxes up front rather than at the end. So on this lovely Saturday morning, welcome to a discussion of death and taxes. Thank you all for being here. So what I'm going to talk to you about is estate planning and what everyone basically needs in place, and then some other things you'll want to think about if real estate happens to be a large portion of what you own, or even a fairly significant portion of what you own, because it comes with its own, I don't want to call them problems, but it comes with its own set of issues that you need to think about ahead of time, particularly if you mean to have that real estate continue on in your family. So let's talk about estate planning in general first. And I know a lot of people think estate planning, and I think it's because of that word estate, is only for very, very wealthy people. And that's not actually true. Estate planning is for pretty much anybody who has anything, because what estate planning is, and this is my own definition of it, which has yet to make it into Wikipedia, but I'm sure it will soon. Estate planning is having an effective plan so that in the event of your death or incapacity, you have taken care of the people you want taken care of, including yourself, and those you do not want taken care of, including the IRS. And what I mean by that is, and you might notice one of the things I said in there was taking care of yourself. And a lot of people tend to think, well, estate planning, I'm dead. I'm not really taking care of myself. I'm taking care of my kids or my family or whoever it is. But that's not true. An effective estate plan also deals with what happens if you become incapacitated. Who's going to be taking care of you? Who's going to be taking care of your stuff? And in this day and age, people are living a lot longer. And we are seeing a lot more of issues with incapacity as people age. So it becomes a significant portion of the planning that needs to go into your own estate plan, whether it's thinking about your parents or yourselves. That's a big piece of it as well. So let's go over what's the basic estate plan, what should pretty much everybody have in place. And the first thing we talk about is powers of attorney. And there are two kinds of powers of attorney. And a power of attorney is something that says, if I become incapacitated, here's who can act on my behalf, and here's what I want them to do. Second part is very key. You're not just turning things over. You've made some decisions in advance. So the first type of power of attorney is, in California, people refer to them as healthcare powers of attorney, but they're actually called healthcare directives. They mean the same thing, but it's a healthcare directive. And that says, if I become incapacitated, here's who's making my healthcare decisions for me, and here's the types of decisions I want to be made. I want to be made on my behalf. How many people remember the Terry Schiavo case down in Florida? We all do, right? It was on television all the time. It was crazy. That was a case that could have easily been resolved with a healthcare directive in place. That was a battle between her parents and her husband over whether she would have wanted to live in the vegetative state that she was in, or what we've come to call pull the plug. And the issue was she didn't have the document in place. Her parents felt one way, her husband felt another way, and years of court battles ensued. A simple advanced healthcare directive says, here's what I would want to do if I was in that situation. It says other things like whether you want to donate organs or not, whether you want to stay in your home for as long as possible, what you want to happen with your remains when you pass away, things like that. It's a fairly straightforward form that everybody should have in place because every one of us is going to die one day. Is anybody disagreeing with me? Okay. If so, come see me afterwards. I want to know your secret. And then also, the healthcare directive, we have been finding lately, this has become an issue for young adults. I put the adults in quotes. They turn 18, they're legally an adult, but if you're their parent, you probably don't view them as an adult. They go away to college, they're an adult. They get in a car accident, they get taken to the hospital. They get sick, they get taken to the hospital. They're far away from you, and you call to find out what's going on. You don't have any authority. They're 18. You're going to need a healthcare directive and a HIPAA form. And we'll talk about the HIPAA form in a moment. So healthcare directive is the first one. The second kind of power of attorney is a financial power of attorney. So that says if I become incapacitated, here's who can take care of my financial matters for me. Insurance, bank accounts, whatever it is. Now, if you have a trust, the power of attorney won't control the trust. But there are still a lot of things, and obviously we're going to talk about trust. There are still a lot of things, even when you have a trust, a lot of assets that might not be in the trust. One of those is retirement plans. Another is probably insurance. So if you're incapacitated because you were in a car accident, and somebody needs to deal with the lawsuit and the insurance that comes from that, that's going to be the person named on your power of attorney. Again, this is something that we find we have to remind clients that if you've got the young adult that is still in some way dependent on you, not married, not out on their own yet, it's a good thing to have a power of attorney in place for them as well. In my own family, my younger brother was in a very serious motorcycle accident when he was about 25 years old, and he was in a coma for a couple of weeks. And after that, still not capacity and not able to deal with any of his own financial matters. He did not have a power of attorney or a healthcare directive. In my defense, I was brand new out of law school when this happened. He didn't have it in place, and we have divorced parents who, we joke, they agreed on two things. One resulted in me and the other my brother. Other than that, so it was a big mess to try and figure out. And it was a little slow getting that one, but you got it now, right? So it was a big mess trying to figure that out and getting them to agree and who could take control in that time period. So if you have young adults in your life, whether they're your own kids or your grandkids or something, think about that. Those are important documents to get in place as well, and certainly for yourself. Aging parents, another one. Definitely you want to have those documents in place. So consider those for yourself, for your parents, for your young adult children. And then another is guardianship for minor children. People tend to think of, if I die, who's going to take care of my children? But what if you're incapacitated? What if again, we'll go to a car accident, one parent dies, the other one is incapacitated, who's taking care of the kids? Or you go on vacation. I know you're parents of young children, you don't get to go on vacation, but let's assume it happens. And you leave your children with your parents, and something happens to the child. Your parents need documents in place that say, we have authority to make healthcare decisions for this child. We have authority to make whatever decisions need to be done. It doesn't just happen automatically, and unfortunately our rules are getting tighter and tighter, and it's harder and harder to have anybody just do things because it makes sense or because you're the grandparent or anything. And again, I mentioned the HIPAA form before. That is a form that everybody needs to have in place, and you can hardly pass by a hospital without them asking you if you have that form. And that's a form that says that the doctors, the caregivers at the hospital, nurses, whoever it is, you're okay to speak to whoever the people are that you've listed. So typically your spouse and your adult children and maybe your parents, depending on your relationship. And so that form is one you need too. So again, the basics would be the Advanced Healthcare Directive, the Power of Attorney for Financial Matters, and the HIPAA form. That's something pretty much everybody needs in place. If you have minor children, you need the similar documents in place. You don't need them for you to have authority over them, but if anybody else ever needs it, say your daycare people, your own parents, whoever watches them on a regular basis, you need documents that say who can handle this. So those are the obvious ones. And then, of course, a will. Everybody thinks about a will. And yes, you need a will in place, even if you have a trust in place. And the reason for that is the will serves as sort of the catch-all when you have a trust. We call them a pour-over will. It says, if I've forgotten anything and there's anything outside here, just put it in the trust and do what the trust says. If you don't have a will in place and you don't have a trust in place and something happens to you, and by something I mean you die, the state of California has already determined where everything's going to go. Now, how many of you are really comfortable with what the state of California might have already decided for you? About as many of you who are going to live forever. So, right. The state of California has in place what's called intestacy laws, and what that means is if you die without a will, here's the formula for where all your stuff is going to go, not based on you, but based on their best guess as to what most people might want. It's a lovely guess. Sometimes it works, sometimes it doesn't. I'll give you a great example of it not working. Long-term married couple with 2 children, same 2 children, same marriage, long-term. Husband dies shortly after inheriting money from his parents. That's his separate property. He dies with some community property and separate property. Under California law, all of the community property will go to the surviving spouse, but the separate property will be split between the children and the surviving spouse. So there will end up being a trust set up for the children, and they will get that money when they turn 18. So that's not a plan anybody would like. I don't care how responsible your 18-year-old is, especially an 18-year-old who loses one of their parents early on. You're not going to want to dump money on them at 18, but that's the plan California has set up for you. So, and there's lots of other ways it could go wrong. Get a will. And if you get a will, then you will at least, even if you don't have a trust, if you have a will, you will at least bypass what California put in place for you. You can at least say in your own will, this is what you want happening, this is where things are going to go. But if your estate is over $150,000, which is not very difficult to do, if you own real estate or trust deeds, you're probably over $150,000. If you have life insurance, you're probably over $150,000. So if you're over $150,000 and you die with a will in place, your will is going to end up going through probate. California loves its attorneys. We have hundreds of thousands of them that we need to keep employed. So California loves them, and probate is therefore very expensive and time-consuming. It takes a minimum of 6 months to get something through probate, and the fees for the attorney start at 4% of the estate that they're managing. So it's expensive, it's time-consuming, it's not anything anybody wants to go to, and it is generally, almost always, going to be more expensive than just getting a trust in place. And I need to mention also, there are certain assets that are not controlled by a will or the laws of intestacy, and those are things you really want to look out for. And so part of your general overview of, do I have everything in place that I need, would also be to take a look at these types of documents. Do you have any assets that are held in joint tenancy? And if you own real estate, that it is for a married couple who owns real estate together, it's very common to take title in joint tenancy. It's kind of old school because we used to not have this thing called community property with right of survivorship, which is better for tax purposes. Everybody just defaults to joint tenancy. Check and see, did you really mean joint tenancy? Is that how you really mean to be holding title? And if it's a married couple, the answer is probably not. You probably meant community property with right of survivorship. We frequently see, particularly with elderly people who don't want to have to deal with a trust or whatnot, they put their property into joint tenancy with a child. They have 3 children, but they don't want to put joint tenancy with all of them. They just put usually the oldest son on title with them in joint tenancy. That is terrible and wrong for many reasons. One of them, if the son, I'm going to pick on the son, after all he got title. If the son is on there and mom dies and property goes to the son and she's saying, well, he'll do the right thing and share it with his 2 siblings, he might, he won't. And even if he wanted to, it's his. It's a gift from him. For tax purposes, it's a gift from him to his siblings because joint tenancy will trump everything. It trumps the will. It trumps what's in the trust. If title is in joint tenancy, the surviving joint tenant is going to win. There might be a lawsuit, and it might settle and change that, but it's going to win, and it's going to cost a lot more money to do it that way. In addition, son that's on title, if he gets in a car accident or gets sued by somebody, that creditor is going to be looking at that asset, and you're at a minimum going to have a fight to prove it's not really his because he didn't pay for anything on it, but there's his name sitting there on title. So you need to go back and take a look at those, at how you've titled things and whether or not you really meant for it to be that way. Life insurance proceeds, also not controlled by a will. They're going to be controlled by a beneficiary designation. What we see with life insurance proceeds, and we see this all the time, when I say we, I mean lawyers who do this for a living. And of course, we only see the problems. I'm sure many of them go just fine. You don't need a lawyer when everything goes just fine. But what we see go wrong is somebody has a life insurance policy that they got with their first job. They were, 25, and they weren't married, they didn't have any kids, and they named mom, because mom always did love them best. So they were going to give it back to mom. And they just forgot. Now they're married and they have kids, but the proceeds are being paid out to mom. Mom may love her in-law, but she's probably still not going to give the money to them, especially at a time like that. She's just lost her beloved child, and the child left her this gift of insurance. It's probably going to stay with mom. And in-law's probably not going to get it when mom passes away. So go back and check your beneficiary designations. We also see beneficiary designations of now ex-spouses. That can be argued, but you've got an expensive court battle to get it undone, and you've got to block the insurance company from distributing the money, which means you have to find out in enough time. So go back and check your life insurance policy beneficiary designations. I've also seen it where I had a client who had, I think it was 6 children, and they listed all 6 children, but there wasn't enough room on the form for all 6 children, so only 4 made it onto the form, and then a little note, C attached, and the other 2 were named on the C attached. The C attached list got lost. Anybody want to bet on whether the 4 wanted to share with the other 2? Nope. And there were 3 other policies where the C attached was attached to it, so we knew what mom and dad wanted, but try telling the 4 kids that. They didn't do it. So it's always worth checking and making sure those forms are updated and they say what you want to say. Retirement plan proceeds, same thing. With retirement plan proceeds, you need to make sure that the beneficiary designation says what you want it to say. If you've said someone other than your spouse has to sign off on that, so make sure you've gotten that accomplished. And this is always a surprise to people. You cannot deal in a will or a trust, you cannot deal with assets you don't own. It seems like common sense, doesn't it? But I will tell you, you don't own the other half of your community property, so you cannot do a plan that gives away all of your spouse's stuff as well. So it takes some careful planning for a married couple to get. I recently had a long meeting with a client who spent an enormous amount of time mapping out his own estate plan before bothering to bring in an attorney, and his own estate plan involved controlling absolutely everything, and even though he was positive he was going to die first, it was going to control everything, and the wife was going to have no say-so in it. Luckily, the wife was in the meeting and realized what he was doing at the same time I realized what he was doing. And she looked at me, and I thought, oh, that's my clue to explain he can't give her stuff away. Call the marriage therapist. But he's still stunned that he can't give it away. So, all right, so those are things you want to take a look at. And those are the basics. So what we've covered so far: advanced healthcare directive, financial power of attorney, HIPAA form, will, and check your beneficiary designations and how you're holding title to your assets. Everybody needs to do at least that much. And then we get to trust, living trust. There is such a thing as what's called a testate trust, and what that is your will say, when I die, set up this trust and do all of this. You almost never see those in California, and the reason for that is the probate that I explained to you before. If you have the trust terms set out in your will has to go to probate and go through that whole process before the trust gets set up. So you will have paid twice as much to get something done. If many of you have friends and family in other states, and you talk about a living trust, and they say, oh, that's silly, that's just a ripoff, that's your attorney trying to make money or something like that. That is because in other states, they don't love their lawyers as much as they love them in California, and probate isn't as complicated and isn't as expensive, so it's quite common in other states, Texas is one of them, to simply have a will that has the trust in it. That's it. It's a lot simpler. It's not true in California. In California, again, if you have more than $150,000 of potentially probated assets, you're going to need a trust in order to avoid probate. And what a trust is you create it during your lifetime. It's a document. It's an entity. Think of it like a business entity, except during your lifetime, it doesn't file its own tax returns. It doesn't have its own tax ID number. It's a document that exists. You transfer title to your property, your investments, your whatever your assets are, into the name of the trust, and you're the trustee during your lifetime. Then when you die, the reason there isn't a probate is because you didn't own anything. Your trust did, and your trust is still alive and well. Your trust has said, when I go, here's who the trustee is that's going to step up. If they can't do it, here's who the next one is, and here's what they're supposed to do. Whether it's divide it up and give it to my kids equally or give it all to charity, whatever it is, your trustee is the one who's carrying that out. There's no judge, there's no court proceeding, unless somebody tries to argue with it, but that is fairly uncommon. So that's what a trust is. And the reason for the trust is because it avoids probate. It controls what happens when you become incapacitated. A will does not do that. A will won't tell us what, because it doesn't even come into play until you pass away. A trust can set out a plan for when you're incapacitated. It maintains privacy. The will gets recorded with the probate court, and anybody who wants to can go down and take a look at your will. That's how celebrities' wills become public knowledge, is someone goes down there, TMZ goes down there and gets a copy of the will. And in states where wills are more common, that's how celebrity wills become public knowledge. Trusts don't become public knowledge. And it maintains control because you've set out all these different options for if this, then that, if not this, then that, and you can set it all out in the trust, whereas wills tend to be, they deal with one or two situations at most. So what are the obstacles to doing this? I see a lot of times, like I mentioned to you, the client who came into my office who had already worked out this whole plan and spent a lot of time and just forgot one small piece, which was that he can't plan for assets he doesn't own. He can't plan for his wife's assets too. And a lot of times I think what prevents people from getting their estate planning in place, besides the who wants to think about death and taxes, except apparently you guys on a beautiful Saturday morning, so thank you. But people don't want to think about it. That's one of the obstacles. One of the other obstacles is they don't know what they want to do. They're thinking, well, okay, I know I need to get a trust in place, but I've got 3 kids, and one of them has, okay, let's go with a drug problem, and one of them I don't like who they're married to, and he or she is a money grabber, and this is going to be a problem, and so I don't know how to deal with it, so I'm not ready yet to go in and deal with it. Which is sort of like saying, I don't feel well, I hurt everywhere, but I don't know what it is, so I'm not ready to go to the doctor yet. Because that's what advisors do. We help you figure out what it is, how we solve the problems that exist for you, and how we walk through what your particular issues are. Because no two families are alike. We never, and everyone who works for me in my office, I always say that, stop trying to do the same thing over again. It's never going to happen. We customize everything. We have to take a look at what's this family, what are their issues, what are their assets, how do we plan for that? So let's take a look at some of the obstacles. And I know for people who own real estate can sometimes be an obstacle to the planning. It's not an obstacle to good financial sense. It's an obstacle to the planning, particularly if there's a lot of real estate or the real estate is key to the family business. And often it'll be that one or maybe 2 kids or maybe an in-law is involved in the business and the others aren't. And then there's the real estate too. So that's one of the things that people can't quite get their head around, so it stops them from getting into their planning to begin with. And then the other issue is that land is not a liquid asset. So if it's a taxable estate, how do you get the money quick enough to be able to pay the estate taxes? We'll talk about taxes a little bit at the end. Right now, anybody can pass $5,460,000 without there being an estate tax. But once you go over, and you can pass that on to anybody you would like, just consider me a volunteer. Anything over that $5,460,000 is subject to estate tax at 45%, and that tax is due in 9 months. So if what you're sitting on is illiquid assets, that can become a problem to get that kind of tax money in 9 months. And as you might guess, the IRS doesn't really sit back and say, yeah, we understand, we'll wait, get it taken care of. They don't. They start charging interest and penalties on it. So those are things that people struggle with, again, particularly with the real estate. So what are the solutions to it? I think one of the common things that happens when people come in is, especially with kids, if they have kids, adult kids, whatever it is, they want to be fair. They either say we want everything to be equal, or we want everything to be fair. And those two things don't mean the same thing. And we don't know what it means to the person saying it, so we have to spend a lot of time figuring that out. So let me give you an example of equal not being fair. If you had $1 million IRA and $1 million piece of property, and you said, okay, I don't want my kids owning things together because they don't get along, so I'm going to give the $1 million IRA to child A, and I'm going to give the piece of property to child B. They're each getting $1 million. That's equal. That's fair. That's great. I promise you neither kid is going to feel that way, because here's what's going to happen. The kid with the IRA is going to say, yeah, but I want real estate. So they're going to liquidate the IRA and find out that they have to pay income tax on it. So they didn't get $1 million. They got $1 million less, probably 42% at that point. They got a lot less than the other child. So they're not going to think that's fair. Now let's say that the kid who got the real estate says, I want to sell it. I don't want to manage real estate. I'm going to sell it. And the one who has the IRA says, this is great. I can continue to earn tax-free. I've got this great vehicle. I've rolled it over to my own IRA. I'm going to continue to accumulate interest tax-free over here in this IRA. The other kid sells the piece of property and invests it and is making 2, 3, 4%, or they invest much better in trust deeds, but they're still paying income tax on what they get. And so the difference in those investments by the end of the whatever the time period is significantly different. So that's what I mean by equal is not always fair. And so we have to look at what are the particular assets, what are the particular goals, and how can we serve that. So when it comes to real estate, there's a couple of options. And again, particularly if the real estate is key to the family business. You can always leave the land and or the business, the real estate and the business, in the trust. So in other words, it doesn't have to distribute. The trust can continue on after you're gone. And you have one kid, maybe the kid who's involved in the business or who understands managing the property best, that child is the one who is the trustee of the trust. So they draw a trustee fee, so they're being paid for their job. They manage everything. The income comes into the trust and then gets distributed out to the kids equally. That would be equal. Whether or not it's fair depends on your children. The child working might think, that's not very fair. I'm working really hard, and if it weren't for me, these guys would have nothing. And the answer to that is that's why you're getting a fee. You're getting paid for that. But after that, everybody's splitting everything. The sale of the land, unless there's a tax situation, the land doesn't have to be sold. The kids aren't going to be arguing among each other because you've said who's going to have control over it. The downside, of course, is the kids who aren't involved in it maybe don't want to sit there and just get the money trickled out to them as it comes in. Maybe they want it sold and they want a whole big piece of it. That requires a conversation sometimes. It could cause hard feelings between the children, because what if the children don't agree that the one who's managing is doing a good job or should have been the one picked in the first place? Where these work best is where there's a conversation during life. And mom and dad, or mom, dad, whoever it is, explains to the kids why they're doing it and how it's being set up. Even better is if the child who's going to be managing starts that management process during mom and dad's life, so we get through any arguments. We see how that child does. Similarly, if the business or the real estate is in an entity, typically that would be an LLC, then you've already set out who's managing the LLC and what happens from there. It's very similar to the trust with slightly different legal ramifications, also slightly different tax ramifications, but it's a way of doing it that allows the business and or the real estate entity to continue on without having to sell off everything. You could also do it with buyout rights. Whatever you're leaving to the, maybe you're leaving it, you are going to leave the land equally, the real estate equally to all three of the kids, but you're going to give one of them the right to buy out the other two, and you're going to set out what those terms are, so that child could make that decision. The reverse can also be true, although it's less common. You can give a forced buyout right to the other two, that they have the right to force the third to buy out. That one gets a little sticky for obvious reasons, but it is a possibility. And I would say on those also you might want to consider insurance. Having insurance, a policy that's there, either that the parents have paid for or the child who's going to buy out the other two has paid for all along, that gives you the cash that's instantly needed to make the buyout there. In the case where the child is the one paying for the life insurance proceeds, then that you have one easy answer. If the child decides not to buy out, well, they've got the insurance proceeds, but they also paid for it, so there's nothing totally unfair about that. And in that case, if they don't exercise the buyout rights, the other kids might have the right to force a sale of the property anyway. So that one child will have that option. I'm either going to buy it out, or I'm just going to keep my insurance proceeds, go buy another piece of property, and we'll sell this one. So it's an option for it. While we're talking about life insurance proceeds, there is also what is known as a life insurance trust, used quite frequently when an estate owns a lot of real estate. And quickly, here's how that works. You set up an irrevocable trust. It's completely separate from your living trust. You set up an irrevocable trust, and you make gifts into it. Anybody can gift annually $14,000 a year to anybody they want to without it being a tax effect and without it eating into your $5,460,000 that you can leave at death. So you can gift this $14,000 to all three kids into this irrevocable trust. There's a period of time, 30 days or whatnot, where they have the right to withdraw that. That's what makes it a gift. You tell them on the side, if you withdraw it, you're cut out of the trust, because the idea is that they don't withdraw it. They don't withdraw it. The trustee uses that to pay the premiums on, if it's mom and dad, a second-to-die life insurance policy. If it's just one parent, on that parent. That way, when that parent dies, the policy pays into this trust out here, and the kids have a pot of money they can use to pay estate taxes. What they do is loan it to the living trust. The living trust pays the estate taxes and then pays them back with other assets later on. Typically, the terms of the trust are fairly similar, so you just have two pots, and eventually we can merge them together. So a life insurance trust, great way to deal with getting some liquidity so that you don't end up having to sell off your real estate assets. We talked about briefly land and or real estate and or the business going to one children, other assets going to another child. This can be done. Again, insurance is helpful in balancing those things out, but we do have to sit down and kind of look at the math on how that's going to work. The land is great. The real estate is great because the child who inherits it at a stepped-up basis. So if they turned around and sold it, they wouldn't have any capital gain at all because their basis in the property is the value at the day they inherited it. So if they turn around and sell it, probably hasn't gone up too much at that point. They don't have any capital gain. So you have to balance that with, are you giving something that's going to be more taxable to the other child? You could leave the business operations or the real estate to the children who are involved and separate it from the land itself, if that's possible. So the operation. I have an office up in Paso Robles also where there's wine, which means there's vineyards and winery owners. And so a lot of those, that's a lot of real estate. That's acres and acres of real estate. But the winery business is often separate from actually the land. So we can separate this group of people, kids, owns the land, and then this child owns the vineyard operations and leases back. So if you have that kind of business where there's a way of doing that, one can own the land, the other can own the business, that's an option as well. And in the last 5 minutes I have left, let's talk about taxes really quickly. So I told you about the $5,430,000 exemption. If you're over that, and so for a married couple, that's $10,860,000. That is scheduled to go up each year unless they change the laws, which they love to do, and next year is an election year. But currently, that's what the law is. If you're over that, you will want to think about doing some tax planning. Tax planning generally involves, giving things away, either to a charity or to an irrevocable trust or to your children or grandchildren. But when it comes down to they get it or the IRS gets it, your children are usually a lot more adorable, right? Okay, your grandchildren are a lot more adorable than the IRS, yes. We talked about the irrevocable life insurance. That's another great way of trying to deal with the taxes. There are also, when I'm talking about giving things away, there are ways to do it in a discounted way, which is to say, if you give $100,000, we know that's a gift of $100,000, and now instead of $5,460,000 when you die, it's $5,360,000 when you die that will be exempt. That can work. It's $100,000, and it'll appreciate over here in the child's bank account. So you've done some gifting. But if instead you had an LLC that had real estate in it, and you gave 10%, say it's $1 million LLC, and you give away 10% of it, that's not a $100,000 gift, because typically the LLC will say you can't sell it, you don't have any control, you can't force a sale, you can't do anything except sit there and collect the money. So that is on the open market that 10% LLC interest is worth less than $100,000. So when you give that away, you've given away only maybe $70,000 that comes off. So you do that enough times, you end up getting a lot more out of your estate at a lower price. That same concept applies when you're doing charitable giving as well. There's different kinds of charitable trusts that can be done. If your kids are not as cute as the IRS, but the charity is, we can work that way. And the last thing I want to cover here, because this gets overlooked a lot, and your real estate people or people interested in real estate, is property taxes. Anytime we transfer real estate, we have to be concerned about a reassessment of property taxes in California. And there is a parent-child exemption, which is very handy, but unfortunately messed up a lot. The parent-child exemption says, if on death a parent transfers property to their child or children, it will not be subject to reassessment. So if you got a piece of property you've hung on to for, at what year did Prop 13 come in? 1975, 77? And you've still got this really low basis in it. I have a client with an apartment building in Laguna Beach that we did everything to make sure that we didn't get that property tax reassessed because they've had it for forever. You want to carry over that can be worth a lot to have that lower property tax. So here's where it gets messed up. If you have a trust that says everything goes to my kids equally, and then mom and dad pass away and the trustee is saying, okay, everything goes equally, but we don't want to split everything a third, a third, a third. I want this piece of property and she wants this piece of property and he wants this piece of property, and everybody says those equal, that's okay, and you distribute it out like that, you won't qualify for the property tax reassessment. And the reason for that is it has to come out of the trust exactly the way the trust said it in order to qualify. So if the trust says equally to my children, all three properties have to come out equally to all three children in order to take advantage of the exclusion. And the exclusion is $1 million of property tax value. So not the fair market value of the property, but the property tax value. So again, if we're talking about a property you've had since the 70s or 80s, you've got 100,000 of property tax value and it's worth $1 million now. You're only using up 100,000 of it. Your principal residence and $1 million of property tax other value. But you have to plan for it ahead of time. So in that scenario, it would have been much better to have talked to the children ahead of time and said, okay, the trust is going to say this property to that child, this property to that child, this property to that child. You would have done everybody a huge, huge favor. And unfortunately, it's too late once they die. And we see it all the time, that the kids just go ahead and distribute it the way they want to, and then we get this massive property tax reassessment. So keep an eye on that. And the last thing I will say is also if you're using LLCs to hold property, a change in control of the LLC, 50%, more than 50%, will cause a reassessment of the underlying property. There's a reporting form for it. It will happen. So all kinds of work needs to be done to avoid that 50%. One of the things that can be done is take the property out of the LLC, make whatever changes you're going to make, move it back into another LLC. When I say make whatever changes, among parent and child. You take it out, you make those changes, you gift a little bit more so that you've passed the 50% outside and use the parent-child, then you put it back into the LLC or a different LLC. It actually works. They make us go through those steps, but it works and you don't get reassessed. So Aaron is standing up in the background there, and I've got to get to Pasadena. I'm sorry I can't be here for questions later, but I did leave my cards and some brochures out front. And so thank you for indulging my schedule.
Thank you.
All right.
I think there was some interest. The last time we did this in Temecula, you did a great presentation on charitable remainder trusts, which I think there was a few people in the audience that wanted. I'll send an email to everyone that registered and provide a link to that because we have it recorded. An extra hour of education for you.
Right.
We'll take a 10-minute break, and we'll come back, and we'll be here with Matt and Amanda with Keystone CPA.